My name is Chris Salentano, and I am the president of the ACS student chapter at Rutgers Newark School of Law. I am excited to introduce the moderator to the Voting Rights Institute training, Jerry Hebert. Jerry Hebert is currently the executive director and director of litigation at the Campaign Legal Center, which he joined in 2004. From 1973 to 1994, Jerry worked for the Department of Justice, where he served in many supervisory capacities, including acting chief, deputy chief, and special litigation counsel in the voting section of the Civil Rights Division. At the DOJ, Jerry also served as the chief trial counsel in over 100 voting rights lawsuits, a number of which were ultimately decided by the U.S. Supreme Court. His full bio is in your brochure, and I advise you all to read it. Without further ado, Jerry Hebert.
Thank you, Chris, and thank you to ACS and UT Law School for hosting this fabulous student convention. I'm really thrilled to be a part of it. It is ironic, as Debo said, that we would be celebrating or having this event on the 50th anniversary of the Bloody Sunday in Selma. Selma is a place very special to me. I spent many years there litigating voting rights cases, and if you're going to be in the pit, Selma is the place, is the pits in many ways. But we've made, black citizens there have made great progress in getting a piece of the pie. I'm honored that at the National Voting Rights Museum in Selma, my name is inscribed as one of the guardians of the Voting Rights Act. One of the things that I wanted to do today was to kind of give you all an overview, and I'll tell you a little bit about how we're going to proceed. It's a little different than usual. I'm going to start by giving probably a 10-minute or so, maybe longer presentation on Shelby County, setting the stage for voting rights cases today. I'm going to talk extensively about the record in the photo ID case out of Texas, because I think it's illustrative of the difficulty of litigating cases today and the burdens that we have to bear. And then I'm going to turn to Dave Richards, who's here on my right, as he was introduced last night, Cecile's father. Although I knew Dave many, many years ago and have admired his career and his groundbreaking efforts in the litigation field, Dave will talk about his experiences arguing and litigating the very first, and here's Gary Bledsoe, so come on up, Gary, take your seat up next here. Yeah, Gary is usually on time, that's true. But he calls attention to himself by coming in a couple minutes late. You're lucky Judge Costa's not here to hold you in contempt, Gary. The bios for all the panelists are on my right, but then after, and Dave will talk a little bit about White v. Regester, which was the very first major vote dilution case in the Supreme Court, decided in 1973, and we'll talk about what that spawned by way of progress. And then I'd like to turn to Gary and Marty, if either one of you can go first, but to talk about the experiences today as litigating cases for the African American community here in Texas, and Marty in your capacity as General Counsel to the Mexican American Legislative Caucus. And then we'll have Senator Wendy Davis talk about her role in the legislature and how that affects the ultimate court case, or the inevitable court case that follows, and how important that action is. And then Chad Dunn will give a wrap-up after that. During the course of each of their presentations, I will undoubtedly interrupt with questions and comments to try to flesh a little something out further. So let's talk about Shelby County. So prior to 2013, the world was pretty good, but then it got not so good. Because prior to 2013, 16 states, that's all or parts of 16 states, were subject to something known as the pre-clearance requirements. And I will say this about the pre-clearance requirements. Now, law professors generally don't make extreme statements. Now, I'm an exception to that rule, I'll confess right now. Section 5 of the Voting Rights Act was the most effective civil rights law ever enacted in the history of our country. And I'm going to explain why in a minute. because you'll see what Shelby County did and why it had such a devastating effect. Until Shelby County, any state or political subdivision in those 16 areas that I mentioned, they made any change that affected voting in any way, no matter how minor, had to undergo pre-clearance review before it could be implemented. And it was legally unenforceable unless and until it was pre-cleared. So if you saw a voting change that was being undertaken, whether it was moving a polling place, changing the entrance to a polling place, doing a redistricting plan, changing a precinct line, changing the hours for registration, the days for early voting, the locations for early voting, whatever it was, it had to undergo pre-clearance first. And it had to be shown in order to get pre-clearance that whatever you were proposing was free of a discriminatory purpose and free of a discriminatory effect. And the effect prong was interpreted by the Supreme Court to say, didn't make it worse off for minority voters. Then, the burden of proof was on the jurisdiction, the state or local government, to demonstrate that the voting change it was proposing was free of a discriminatory purpose and effect. That's huge. And then to get pre-clearance, you either had to go to DOJ in Washington, which 99.9% of all the jurisdictions did, or to a special court in Washington, D.C. Now, in Shelby County, the Supreme Court decided 5-4. It strikes down not the pre-clearance provision of Section 5, it strikes down the coverage formula that brought in those 16 states. And it did so, remembering, though, that these 16 states were originally brought in because of their long history of discrimination and the fact that they had decreased minority turnout and decreased voter registration rates. But it was declared unconstitutional. This is the part that, as a law professor, I almost burst out laughing hysterically every time I say this. But it was declared an unconstitutional violation of the Constitution's guarantee of equality among the states doctrine, which, as I recall, was only a doctrine that was applied to decide which states could be readmitted to the Union. So it seems like a stretch to me, but we'll leave that for another day. It renders pre-clearance, though, a nullity, because if nobody's subject to this coverage formula anymore, it really doesn't matter if you have pre-clearance. The Supreme Court, in its very politically wisdom, said, oh, well, Congress can just go ahead and craft a new formula. And, of course, maybe they know something we don't know about current Congress and their ability to craft anything. But it said it can devise a new formula based on, quote, current conditions. And the court said the formula that it struck down, which was based on data 40 years ago, was seriously out of date, and it didn't reflect current conditions anywhere in the country. Always nice when you see the Supreme Court litigating from up on high like that and making the determination about what's really going on in the hitherlands outside the Beltway. Last time I checked, though, I thought that Congress was the entity that was supposed to do that under the 14th and 15th Amendment, but maybe that Constitution that's in your packet, maybe they changed the 14th and 15th Amendments without my knowing. Section 2 of the Voting Rights Act has been left intact, at least for now, until John Roberts gets his hands on that. Section 2, by the way, is the key provision of the Voting Rights Act. It is the major enforcement provision. Dave is going to talk a little bit about referencing Section 2 when he talks about White v. Register, and I'm going to prompt a couple of give and takes on that, I suspect. Now, the impact of the decision in Shelby was, at least in Texas, for example, the D.C. court, where Greg Abbott had gone to get pre-clearance of his photo ID law, that had been blocked from going into effect because a 3-judge federal court found it to be discriminatory and therefore not pre-clearable under Section 5. And that case went up on appeal. It was held on appeal until Shelby was decided, and the Supreme Court then vacated the judgment and remanded in light of Shelby, which of course the D.C. court then dismissed the case. One key point to think about, though, is that the D.C. court's findings of fact, they weren't vacated by the Supreme Court. The Supreme Court just vacated the judgment with respect to pre-clearance. So all the facts, which I'm going to go through in a minute, about the photo ID case that the D.C. court found, even though that can't be cited as legal precedent because the judgment was vacated, those facts are still facts. The same with respect to redistricting, which the D.C. court also had turned down. Greg Abbott announced, he tweeted right after the decision in Shelby County that, hey, the photo ID law is in effect. He did that, though, notwithstanding the fact that judgment in the D.C. court had not yet been vacated. So I thought that was a little strange for a highest law enforcement in the state to not kind of give full faith and credit to an outstanding injunction. I guess I spent not enough time on that. A few days later, Congressman Vesey filed a lawsuit in federal court because, remember, the photo ID decision in D.C., the burden of proof was on the state. Well, now with the Section 5 preclearance and nullity, we had to then go in and file a lawsuit. When I say we, I'll say full disclosure, 3 lawyers on this panel, myself, Dave Richards, and Chad Dunn, represent Congressman Vesey in that case, along with some other counsel, including Josh Bone, who's a lawyer in my office, who's back there and helping us on the case. And we brought 4 claims. We brought a claim under Section 2 of the Voting Rights Act. We brought a purposeful discrimination claim under the 14th and 15th Amendment. Note, too, that even though Section 2 of the Voting Rights Act is a results test, you can also violate Section 2 if you prove that the discriminatory practice you're challenging was purposefully discriminatory as well. We brought something called a Crawford claim. Those of you who really are into voting rights have probably read Crawford versus Marion County, the Indiana photo ID case. I'm going to talk a little bit about that and how it differentiates from our case in Texas. And then we brought something called a very unusual challenge, a poll tax case. So Crawford versus Marion County, briefly, there's 4 things about it I want to call your attention to. And now we have people here getting CLE credit, so I'm doing a little bit more legalese than you're probably used to, but you can stand it, I think, even if you're not in your regular classrooms. So first of all, Crawford was a facial challenge seeking to have Indiana's voter ID law declared unconstitutional. And a facial challenge means it can't be applied in any circumstance, and it applies to all voters. So it's unconstitutional in all circumstances as applied to all voters. You probably have heard in law school already that usually bad cases make bad law. This is probably the best example of that you can remember, because they challenged it before it went into effect. And so therefore, it's difficult to establish, 9 nuns who have been voting for decades who suddenly are denied the right to vote by the Mother Superior, who is the poll official in Indiana, which actually happened, but after the case went up to the Supreme Court. So bringing a case, timing is everything, and when to bring it. It was a less restrictive ID law than the one in Texas. It allowed all federal and state-issued photo IDs, and if you couldn't afford one and you could sign an affidavit saying so, that you were indigent, you got to vote. That's pretty good ameliorative provision. No evidence about the number of Indiana voters who lacked ID because, again, the case was brought before the law went into effect. And there was little evidence that the voter ID law imposed significant burdens on voters who lacked ID, and little specific evidence that the voter ID failed to advance the state's asserted interest. The state's asserted interest in Indiana was that there was voter fraud to be concerned about. How many cases of voter fraud were there in Indiana that justified this law? If you said none, you would be correct. They had to actually go back to Boss Tweed as an example, Justice Stevens did, of the kind of fraud that we should all be concerned about. Our case is an as-applied challenge. We seek only relief for those Texans who lack the SB 14, which is the photo ID law, compliant IDs. We claim it's an extremely burdensome photo ID. We're trying to draw as much distinction from Indiana because it allows only certain limited forms of ID. For example, I was telling some of you students at lunch that if you are a federal FBI agent and you go to the polls to vote and you present your federal credentials, your FBI credentials with your picture on it, that's not a compliant SB 14 ID. If you're a state employee and you work in the governor's office and you show, or your attorney general's office and you show your state ID, that doesn't entitle you to vote. We presented extensive evidence, I think, that's suggesting that a large number of Texans lack an ID. I'm going to go into that. Extensive evidence about the burdens that are faced by voters that they have to overcome in order to get an ID. And then we said that it failed to advance states' asserted interest in preventing voter fraud and increasing confidence in elections. Now, Texas, when it went through this debate, said, oh, all photo ID laws are okay because Crawford said so. Well, no, that's not a correct description of what Crawford did at all. And they then said, well, we're just going to model our law after Indiana. Well, I just gave you examples of how there's no indigent provision in Texas like there was in Indiana. And in Georgia, you don't need a birth certificate to get a free ID in Georgia, but you do in Texas. You have to get a certified copy of your birth certificate, which I'm going to explain in a minute, is not free at all, the ID. And in Georgia, you can get it at any county registrar's office or driver's license office. And as Wendy Davis is going to talk about a little later, there's evidence that a number of amendments were offered to try to ameliorate SB 14 and make it more like Indiana and more like Georgia, which was being claimed by its proponents, but they were all rejected. So one of the things I think that we decided to focus on in the ID case was this. Every time that Texas made a decision about what IDs could be used, they picked an ID that was overly represented by Anglos. And every time they rejected an ID, it was one where African Americans or Latinos were disproportionately represented. So, for example, if you have a license to carry a firearm in Texas, which 90% of the people who do are Anglo, that's okay, you can have an ID, even though you don't have to be a citizen to have a license to carry. So much for the our state interest that, well, we need this ID to prevent non-citizens from voting. Secondly, University of Texas IDs or any student ID is not allowed to be used. Federal and state employee IDs. And in those groups, there's evidence that at the time, Texas knew that those disproportionately helped minorities, and that's why they lopped them off as the forms of ID. Prior sessions of the legislature where ID bills had been considered and Democrats had been successful in blocking such ID requirements, in those sessions, some of these IDs were actually permitted. But then when Texas really got the supermajority to enact the law that they did in 2011, the same year they enacted intentionally discriminatory redistricting plans, that's when they took away some of the IDs that I just mentioned. And they didn't have it applied to voting by mail, so to the extent that there is any voter fraud in Texas, voter by mail in Texas is overwhelmingly, again, disproportionately used by Anglos, so it didn't apply there. And the other thing was, if you want to get a EIC, which is called an Election Information Certificate, this is a little ID that you can get that only allows you to vote. It's a picture ID, and it says to be used for voting purposes only. You can't use it for any other purpose. In order to get it, you have to get a certified copy of your birth certificate, which I'm going to talk about in a minute, is not free. But even worse, if you want to get a certified copy of your birth certificate for a reason other than getting an EIC, you can do it online or you can do it by mail. But if you want to get an EIC just for voting, you have to go down in person. So another burden, I would argue, on voters. For the first time in Texas history, DPS, a law enforcement agency, was the de facto voter registration agency because that's where you have to get the ID. And you can't vote. So the voter registration offices are largely now meaningless. You go down there and register to vote in every county, but that doesn't entitle you to cast a ballot. You've got to have a photo ID. Getting this EIC, Texas made little effort to educate people. We put on evidence about that. In fact, until trial, the DPS website contained no Spanish language information about the EIC program. And so when we had the witness on the stand for the state from the DPS office, we said, okay, let's bring up in the courtroom, let's bring up the DPS website. And they brought it up, and it was like, oh my God, it's like, don't ask a question you don't know the answer to. I thought, oh my God, what have we done? Because there's a Spanish thing right there. And then my able co-counsel, Chad Dunn, one of the others said, by the way, when did you put that Spanish button up there? Last night. Even the judge got that joke. DPS received no dedicated funding for the program, and get this, the DPS employee responsible for implementing it said he spends little time on the program and suggested that The fewer EICs his office issues, the better. Widely dispersed throughout the state, 78 of 254 counties don't even have a DPS office. Rare exceptions, open only during work hours, largely inaccessible by public transportation. They then fingerprinted and threatened to conduct warrant checks on people who applied for EICs. That might have a chilling effect. You know, if I have a speeding ticket, I'm probably not going to go down there and risk going down there. And as I say, until trial, did nothing to combat the public perception that it still fingerprints people when they come in for that. Here's some actual testimony. Let me ask a little bit about Ruby Barber. She was an Anglo woman up in the Waco area, I believe, Chad, right? And she was a woman who got an EIC without having the documents required by regulations. And we were wondering about this, how this happened. And so we called Ms. Barber and we took her deposition. And she said, well, I went down there to get it and they denied me the right to do it. And then I went and I told the local television station. And lo and behold, I got a call from the Secretary of State or DPS and they told me to go back there. So my son took me back there, so a white woman in her 80s. She goes back there and they say, well, do you have a certified copy of your birth certificate? She says, no, I was born in Tennessee. And there's no record of my birth. I was born to a midwife. And they said, well, wait a minute. Oh, yeah, we just looked and saw that the census in 1918 shows that your parents had a baby. That must be you. Okay, here's your ID. I mean, come on, really, seriously? If that woman had been black, they would have said, sorry, no ID, you're out of here. Because I'm going to show you, we put on witnesses that had that happen. She says, I didn't have documents, that's correct. We go all the way through. And we say to the DPS agent, so you moved heaven and earth to go find the census form from her birth in Tennessee, correct? He said, well, I didn't. One of our customer service agents did. Oh, that's so helpful. Thank you so much. Issuance by DPS. From June of 2013, the time of Greg Abbott's tweet, 15 months later, they issued 279 EICs. Georgia, a state less than half the size of Texas, issued 2,100 in the last half of 2006 when their photo ID went into effect. Tony Rodriguez, the senior manager at DPS, when he was told that there were 0 EICs issued, he said 0 is a good number. And then when the lack of EIC applications persisted, he wrote, this is getting better by the day. These are emails that we were able to get in discovery. And he told the director of the driver's license division who asked about these EICs, we had a close call. We almost had to issue somebody a free EIC, but that we had a clean sweep. They had issued none in those first few months. It's devastating testimony when you can get it. So, a pretext of discrimination, I call this slide. So Texas says, well, we wanted to stop in-person voter fraud. Think about in-person voter fraud. I go to the polls. I'm going to be Dave Richards, right? So I'm going to go in and I'm going to vote for Dave Richards. Now, first thing I have to hope is that the officials don't know Dave Richards. Because if they do, they know I ain't him, right? I also have to hope that they don't know me. Because if they know that I'm Jerry Hebert, they know I'm not Dave Richards. Secondly, I got to hope he hasn't already voted that day. Because if he has, and I go in trying to vote for him, they'll go, you already voted. And then, oh, that's not going to look good. And then I'm doing it in front of eyewitnesses, many of whom can ID me later as being a perpetrator. That is why you don't see voter impersonation fraud happen. There were no election outcomes shown to have changed with in-person voter fraud. There were only 2 cases in the last 14 years, despite the state's best investigation. We put on testimony from Buck Wood, a lawyer who had been like 40 years practicing law, former director of elections in the Secretary of State's office, saying that he had never seen voter impersonation fraud, and that it's easy to detect. And to the extent there is voter fraud, it's happening by mail, which photo ID laws don't have anything about. We put on Dr. Alan Lichtman. He described a proposed amendment after proposed amendment that was rejected, despite the fact that they would have racial effects. And then, of course, we put on the history of discrimination in Texas. And I always like to say, and there are great people in Texas, don't get me wrong. There are some great people in Texas. And Texas is a great state. But Texas has been discriminating for so long and in such a deep way against minority voters that they've almost lost the shame for doing so. And that's really, I think, a bad situation for many Texans who like to think of their state in a much better light. Here are the experts who, we had several experts. One of our experts, Dr. Herron, did a statistical analysis and found that of the millions of voters in Texas on the roll, 619,000 lacked any of the IDs that the Texas photo ID law said. Dr. Insola Beher, the government's expert, DOJ, he said he calculated 608,000. We did a survey of Dr. Barreto and Dr. Sanchez. They came up with 516,000. And they also found that there were over 1 million eligible voters, meaning people who weren't yet registered, but they knew lacked ID and were of voting age. And then Ann McGeehan of the Secretary of State's office, who used to be in the SOS, Secretary of State's office, they had done a data match at the time they did it. They denied ever producing, having such data. When legislators asked, well, have you ever done any analysis of who lacks the ID? They all said, no, I'm not informed of anything like that, but you know. Well, it turns out they did have one, and they knew that 800,000 people, according to their calculation. Always nice when you can show that somebody's got their pants on fire, to quote a 6th grade expression. So I entitled this one, this is one of Chad Dunn's favorites, Never a Good Idea to Build an Airplane While Building It. That was a quote from the head of the Department of Elections for the Secretary of State about their ability to implement the photo ID law. Doesn't sound like a safe flight to me, you know? You might want to buckle your seatbelt on that. Or better yet, maybe not get on the plane at all. It's passed in the spring of 2011. Shelby County comes down. They move to implement it within hours. And then he says it's a rocky start. They have all these problems. And they admit that the process is rocky. They announced there would be fingerprint checks for people who applied, background checks. There was misinformation on the website. The website was updated during the trial, as I said earlier. Mobile units had people, they sent mobile units out to give people ID with almost no notice to local officials. There was no signage at the DPS office for the issuance. They spent only $400,000 to implement it, and not one penny was spent to inform voters. All they did is spend money to say, hey, we now have a photo ID law in Texas. Well, I think pretty much everybody knew that already. They could have maybe spent that money telling people how to get the IDs. Georgia spent $700 grand, by the way, to ensure voter registrars in its counties could issue EICs. And if you all have cell phones, which you probably do, with a picture-taking capability, you could take pictures right there at the registrar's office and print out somebody's ID. It's about $400 to get the equipment to do that. I told you about the few number of EICs issued, the poll tax claim. So it's undisputed, and it was undisputed at trial. Oh, by the way, the Texas expert, they put on an expert. He said, I didn't do my own analysis, but I got to say, these experts on the other side, pretty much I agree with their numbers. It's always helpful. Thanks for not doing your own analysis, first of all. And then secondly, thanks for validating mine. Always helpful. Poll tax struck down in U.S. v. Texas back in '66. Was that your case? No. The government brought that case. Here's what Texas does with getting an EIC. So if you go in to get an EIC, as I said earlier, you got to produce a certified copy of your birth certificate. $22 you have to pay. Now Texas said, well, we're going to make it free, so we're going to waive all the fees. Well, there was one fee they couldn't waive, which was a statutory fee of $2, administrative fee. Some counties made it $3. So you had to pay at least $2 or $3. But here's the thing. We put on witnesses who said, well, yeah, I'm responsible for issuing the EICs. So I come in and I say to you, I want an EIC. What do you say to me? They say, well, it's $22. I go, well, don't you tell them about the $2 discount? And they go, only if they ask. Well, that's helpful. Thanks for that, too. You know, this is just the gift that keeps on giving in this deposition. So then you go through the trial, you know, and you get people saying that, you know, well, I tried to get a birth certificate, but I don't live in Texas. I live in New Jersey. I was born in New Jersey. And it cost me $66. And I don't have $66. Texas's cross-examination of these people was to say, all right, let's go through. How much do you get in Medicaid? How much do you get Social Security? Let's add up all your income for the month. And say you get $1,800. Now let's go through your rent and your utilities and see, oh wait, you have $12 left at the end of the month. If you just waited 5 months, you'd have the $60 to send to New Jersey. And you know what the witness said? You can't eat a birth certificate. I need to eat, and my family needs to eat. Great stuff. Don't ask a question you don't know the answer to in cross-examination. You probably have heard that. So, Wendy Davis offered an amendment that would have reimbursed Texans for all costs associated with getting the underlying documents to obtain an EIC. And that, like all of the other amendments she offered, failed. So Texas adopted a law that requires someone to obtain a birth certificate in order to vote. They knew that it would cost $2 to $3. They knew 25% of the Texans, according to the census, were born in other states, so they would have to pay. Texas rejected amendments to address all the concerns. We put on Ken Gandy, one of our plaintiffs, who said, I can't vote in person because I don't have the money to pay to get an ID, but he's the head election official in the Nueces County polling place where he works. But he can't vote in the polling place where he's the chief poll official. Finally, this is now your governor, used to be Greg Abbott, Attorney General. He went around the state, let me just go here. He went around the state. He said, investigating elections code violations. I'm going to train people on how to spot voter fraud. Who's committing voter fraud? I want to know, says Greg Abbott. So what does he do? He has, these are his slides. These are his training slides. Dead people voting. The Sixth Sense, 1999. I see dead people voting. They're everywhere. They don't know they're dead. They just keep voting. 2 instances out of like 28 million Texans who voted committed impersonation fraud. So then he says, yeah, look at me. I have 3 indictments in 2005. I have these voter and fraud indictments. Hardeman County Commissioner, a Beeville woman for mail-in ballot, and another illegal ballot handling in Robstown. So first of all, none of these involved voter impersonation. But if you really want to try to convince people that there's voter fraud going on, you can't just have slides like this. You have to go over the top. And Governor Abbott now did go over the top. Here's who he said voted in person, committing voter fraud. And those are all black people. What kind of a racial cue do you think that might send? That Greg Abbott is telling people, all laws applies to voting in person, and you can commit voter fraud, and these are election code violations, so let's just show some black people all lined up to vote. So you might say, well, maybe, that was a picture they had, they got it, off Photoshop or something. So then he has another one. He says, examine documents for vote fraud. Obvious signs of tampering. So he's got a Scotch tape roll. Some handwriting on the form, different from signature. This is getting really, really mysterious, isn't it? Then, my all-time favorite, and this is a slide did you put this up in closing argument? Yeah, in the photo ID case. I put it up in the DC court. Chad put it up in Corpus Christi. But what I'm about to show you is the one that really puts it over the top. Because he says that the people who commit these voter fraud, they use unique stamps. You think it's a forever stamp? No. Sickle cell anemia stamp. How about that? You groan just like the judges did. Just like the judges did. You can't make that up. You can't make that up. So that's who your governor is. Some people say these are racist. I'm not going to say that today. I've said it before. I'll let you make up your own mind. So, with that intro, David Richards, you've litigated tons of voting rights cases. Tell us about how you used to do it in White v. Regester, and you've come all the way to litigating new voting rights claims, even under a case called Lario v. Cox, and if you could hit that at some point. But tell us, David, about your experiences in the voting field historically.
Well, let's see. I guess what I want to start with is if you're serious about pursuing reform through litigation, you got 2 things you got to start with. Venue. You don't start cases in Indiana over discrimination against black people, because that's not where it's going on. It's going on here in Texas, and it's going on throughout the Old South. So forum selection is absolutely critical to anything you do. Some people call it forum shopping in a pejorative sense. I consider it to be the height of good lawyering. The second thing you have to know and realize, and having heard Jerry, it reinforces it, you have to have a factual, appealing case. And you can't get caught up with legal theories that somehow redound to sound as if ineluctable. The reality is, by the time you get up to an appellate court, they think they know what the law is, but they don't know beans about what the facts are. And that's what you're going to get questions about. Who shot John? And this is why when you get ready to do one of these things, any case of reform, whether it's in voting anywhere else, have appealing facts, because that is, frankly, the linchpin of most successful litigation. White versus Regester arose after the 1970 redistricting. The Supreme Court had said in at least one case and prohibited another that at-large districts had the potential for minimizing minority voters' voting stream. And that seems self-evident if you lived in a place like I lived at the time, Dallas, Texas, which had a reputation, well-deserved reputation, for discrimination all across the board. The black population was in the 12–15% range. We had, with that census, we had 19 legislators, House members, to be elected at large. And of course, it meant that no matter what black voters did, their votes were going to be submerged and disappear in the overwhelming white electorate. So that was sort of set the stage for the litigation. And the other thing about litigation to realize is that your plans gain off to glaze. So our theory was we were going to do this on a slow train. We thought we would be able to file it and get a venue in front of Wayne Justice, who was the U.S. District Judge in East Texas, to whom all civil rights cases got to, if you could. And our assumption was that we would try it as a declaratory judgment case, that is, not invoking the three-judge court principle, on the assumption it's going to take us a long time, but we could get out of Judge Justice with any luck really fact findings that would sustain us on appeal, and that was our theory. So I didn't have a plaintiff in East Texas, and I called my old friend Bill Kugel. I said, Bill, I've got to file tomorrow, and I need a plaintiff. And he called me back, and he said, well, ID Redistricting. Okay, so ID Redistricting became the lead plaintiff, and to this day, I've never spoken to her, and I had an occasional thought that she might not even exist, but but by that's, you know, that's my, the limitations is passed, and before I was through, I joined a lot of real people who I could find. So anyway, but it was filed, and the next day, a group of conservative Democrats who ran Dallas County politics copied my pleadings, grabbed themselves some plaintiffs, and filed a new lawsuit in Dallas, obviously trying to fix venue in Dallas County. And then that became the first battleground, which we managed to win. And then a couple other lawsuits got filed, and suddenly our declaratory judgment action became an injunction action. And so we geared up for that. I filed a lawsuit in November, early November. The judge set it for trial in the 1st of January, the second day or third day of January. Now, this is a fairly complicated case. And here we are. The redistricting panel, or legislative redistricting board, had created the plan, including the Lieutenant Governor of Texas and the Attorney General of Texas. So over the Christmas holidays, I'm taking the depositions of Lieutenant Governor Barnes and Attorney General Martin, and we have our pretrial on New Year's Day, if you can believe it. And that was, we compressed within less than 2 months this case. And we were benefited by the fact, I don't mean that the state, Leon Jaworski, who had a big reputation around, volunteered to represent the state. And the one thing you do benefit occasionally by is you have an opponent whose ego outstrips their understanding. In this particular instance, we were benefited by that enormously because they sort of poo-pooed our case as if it were somewhere out in the hinterland. In any event, we put it on. There was then State Senator Oscar Mawsey, who had been my law partner, and he was going to try it with me, and I decided that he would be better as a witness than as a lawyer, so we took him off the pleadings, and he was an absolute student of politics in the state and was a fabulous witness, and I used him later in another case. It turns out, if you're careful with politicians, you can use them as a witness, but as a general rule, don't use them because their egos get in the way of their testimony. But
So when you get a good witness like that, do you put them on first, do you put them on last, or do you try to put them on after a bad witness?
Well, we were so much by the seat of our pants in that case. I think we just put on whoever showed up kind of thing.
That's another rule.
We put in, I mean, we gathered, I can remember my old friend George Corbel was representing Maldeff in the litigation, and we put in newspaper clippings in by the bail. I mean, we just put in everything, and the court just took it all. And we didn't know what we put in. The other side obviously didn't know either. But the upshot of it was we put on a pretty strong case, and the thing, though, of course, about at-large districts is that when you think about it and you do it in the context of what we call racially polarized voting, it's pretty self-evident that it has that potential for dilution of minority votes. And there were several kind of fun things. Texas had been through, as it is every decade, lengthy redistricting litigation in the 60s. And in the late 60s, they had cut Harris County, the largest county in the state, into sub-districts. And they explained to the federal court in that case that Texas had a policy that any time a county reached 1 million in population, then they would be cut into districts. Now that explanation was given to the federal court in 1968. 1971, Dallas County had 1 million people in it, and somehow that cemented state policy disappeared in smoke, never to be seen again. I mean, that was that's what you get when you litigate against Texas, frankly, this sort of hokum throughout. But in all events, we won it. The court took it. The case, I knew I'd already won the case when Chief Judge Brown into the Fifth Circuit, the three-judge court, if you probably know or don't know, configured by the judge before whom you file the case, and this is Wayne Justice, and the presiding judge of the Fifth Circuit names the other two members. Well, Chief Judge Brown named Irving Goldberg as my circuit judge on the panel, and the truth of the matter is, I say, I knew then that the handwriting was on the wall. These were the two most liberal sitting federal judges probably in the country at that time. So I thought we were kind of like a Christian with 5 aces as we go into this thing. But we worked hard, we tried the case hard, and then we presented our proposed remedy, which was single-member districts for Dallas and Bexar County. The districts were drawn by my old friend Dan Weiser from Dallas, and he managed to figure out how to create the greatest districts imaginable. And the state, thanks to Leon Jaworski, decided they would give too much credence to our lawsuit if they presented alternative plans for our plans. The only plans presented to the court implemented it. It went up on stay. Voting litigation is essentially stay litigation. I mean, it's crazy, but it absolutely is, because it's all momentum and inertia. That is, if your case gets stayed, What the hell, you're 3 years down the line. If it doesn't get stayed, as it was in our case, we ran the elections, and by that point, it's obvious that the legislature is not going to monkey with incumbents. By the time we got them, you already cemented them in place, basically. When we got ready to try the case, Armin Durfner, who was the guru of all voting rights at the time, was helping us. Armin was South Carolina. And he said, let's throw in a deviation claim just for the hell of it. So we threw in a deviation claim. No one even, it was just lost there in the case. No one ever talked about it. It was just, the classic population, one person, one vote claim. It gets to the U.S. Supreme Court. No one mentions deviation. We all argue the single-member district point on all sides. The state, we had, by the way, on our side, the Republican Party of Texas at the time, represented by Tom G., who later became a Fifth Circuit judge and was a brilliant lawyer, because Republicans were in the same boat in the old one-party Texas system. They were excluded essentially from politics. And we win. We lose the deviation, which we didn't care about. We win the single-member district, which was the core of the case, unanimously, almost as an aside. And the one thing I guess that should taught me, as I've learned again and again, once the case gets moving up the line, lawyers sort of control the case at the trial court level. They frame the issue and sort of are able to, once it gets in the hands of something like the U.S. Supreme Court, you're just a pawn in their agenda, and that's, sometimes good, sometimes bad, but it was in this instance. So they decided what became the core single-member district issue almost as an afterthought if you read the opinion. But of course, almost instantly after that, everywhere you turned around, there were single-member district lawsuits being filed all across the South, and many of them successful. And a serious revolution occurred in the representation of minority voters everywhere in fairly short order. White versus Regester was a 14th Amendment case. This wasn't a Voting Rights Act nonsense in that case. It was the 14th Amendment. And Congress can do what they want to do, and the court can muddle around, but the 14th Amendment still exists. And if you're going to do in the future, you're going to have to begin to think about it. There's politically no replacement coming for Section 5, in my opinion. And so you're going to have to revisit the 14th Amendment cases, and they aren't all bad. Some of them are quite good. And indeed, you're talking about the Indiana voter ID case. They adopt the 14th Amendment analysis there, which is totally, you can live with, I think. And so you've got to begin to live with that. The second thing Jerry wanted me to mention was the Lario's case, which has become kind of a wild card. It's a strange one, but it's essentially a 14th Amendment case too, in the sense that when the Supreme Court decided White versus Regester, in dealing with state redistricting on the population issues, that is one person, one vote, they said we're going to cut the states some slack when they do their redistricting with respect to their own legislative bodies, House and Senate, and so if the deviation is no greater than 10%, we're going to just assume that that's okay. And that, as all things happen, by that we mean 5% up, 5% down, total 10% variance from the ideal. Well, of course, every legislature, and their lawyers all immediately decided that 10% was a safe harbor. The law, the 14th Amendment law, remained that you had to make a good faith effort to population equality, but the reality is what the states did, they made a good faith effort to stay within 10%. That's if you look anywhere you look, you see that going on today. In Georgia, I guess I lost track of time. I think, that's right, 2000. There, of all things, the Democrats controlled Georgia at that time, and they redistricted their House and Senate in a purposefully discriminatory way on the basis of partisanship. That is, they stacked the deck for Democrats. And the Georgia three-judge court found that if partisanship was taint is too weak a word, I guess, infected the redistricting plan. The state lost their 10% safe harbor. And it went to the Supreme Court. They did not take the case, but they affirmed it as because it's a 3-judge court case coming up, and once they take it, they got to do something with it. So they affirmed it. And so I guess that's the law as we understand it today. And I think it's explainable in the sense that the courts have grappled with partisanship or gerrymandering, and they don't like it, and they're frustrated, I think, because they've not been able to get a handle on trying to address it. And or this sort of gave them, or gives them if they want it, a handle to say, well, okay, if it's partisanship and partisan gerrymandering, then you're going to be held to the stricter standard of one person, one vote, and equality of districts. We'll see how it plays out, but I've thrown it into the current litigation of the state. And I'll leave this, people coming behind me can talk more about it, because we are litigating today, well, we're one more trough waiting for a court to act, but we're litigating the last round of redistricting in Texas. And the state has come in and said, it's non-discriminatory on the basis of race or ethnicity. It's just partisanship. We want to ensure the election of as many Republicans as possible, and hence this line is drawn this way to elect Republicans or protect Republicans. And the mere fact that that is accomplished by dividing minority communities in half and shipping them off into alien spots is not discrimination on the basis of race, but it worse discrimination on the basis of party affiliation, and everybody knows that blacks and Hispanics vote Democratic. Now that issue I don't know if this court's going to have the courage to deal with it. I don't know if any, but it is the court's lurks here full scale and is problematic. But the reality is that's always been what we were talking about. They didn't like the way, in my case in Dallas, they didn't like the way black people voted. So they didn't want them having any swat at the polls because the results they weren't going to like. And this is essentially the same damn thing, although they now labor on partisanship and think they can skate, and they perhaps can, but that's I think a core issue.
Thank you, David. You know, David mentioned the Supreme Court finds partisan gerrymandering distasteful, a case called Veith versus Jubilaera, which was a case that I was involved in and went to the Supreme Court, another 5-4 loss. For us, the court says, you know, political gerrymandering is justiciable, but they couldn't agree on a principle that would actually define what partisan gerrymandering rose to the level of being unconstitutional. When did it become too excessive? So I always like to say that they left it justiciable, they just haven't justiced it yet. So we're kind of waiting on that. So Marty, I'd like you to talk a little bit, or if you could, about some of the issues that are facing Latinos in Texas today, including maybe referencing some of the redistricting stuff. And I'm interested if any of you have comments about Dave's last point, which is really critical, which is if the state can say that we're discriminating on the basis of partisanship because Veith gives us protection because you can't come up with a legal standard for it, then basically we can say we can discriminate to the max against blacks and Latinos because they vote Democratic. And we know they vote Democratic, and if we can just do whatever we want in terms of redistricting and maximize our partisan advantage, you're going to have a license to discriminate against blacks and Latinos. Marty?
Hi, my name is Martin Galando. Marty, please. I'm the General Counsel for the Mexican American Legislative Caucus. I want to thank you for inviting me. And it's a unique pleasure for me because there's nothing I like more than talking about voting rights. And this panel is the all-star panel. Jerry Hebert's like the Babe Ruth of voting rights. And I'm like the Forrest Gump of voting rights. So why am I here? So when you look at historical pictures and you see like LBJ signing the VRA, off to the side there's always like a staffer. There's like sitting right there. That was me for about 10 years. I was a staffer for Trey Martinez Fisher for about a decade. And Trey was the chairman of the Mexican American Legislative Caucus. And when we began this redistricting fight, and that's how I got my job, essentially. The Mexican American Legislative Caucus is a 40-member caucus of the Texas House of Representatives. It is a bipartisan caucus. They are both Democrats and Republicans as part of the caucus. It is a rural and urban and suburban caucus. It's very both politically diverse and geographically diverse. So it presents some unique redistricting problems. But Jerry's asked me here to talk about what Latinos face with voting rights changes. Let me first begin by saying voter ID requirement uniquely affects Latinos in a couple different ways. Culturally, voter ID prevents Latinos from voting because of the double name history of Latinos. My boss, Trey Martinez-Fisher, my client now, has a double name. His mother's name was Martinez, his father's name was Fisher, right? For years, his went by the name Tracy Fisher. That was his name in high school, and that was his name in middle school. And when his father passed away in college, he adopted his mother's name to give honor to both of his parents. So as a consequence, is a name he adopted in order to recognize his cultural identity, a name he adopted to give honor to his father, actually could have hurt him with this law, right? Because his name is actually Ferdinand Frank Fisher.